Okay, so you may have seen that Lucy Letby, the nurse, was convicted on the retrial of some of the counts on the indictment that there'd previously been a hung jury on. But what I want to talk about is two aspects of things that were embargoed. But now I am free to talk about them, and I'm trying to get these as a scoop because they'll probably be in tomorrow morning's newspaper, but I'm hoping to get them a bit quicker. So there were two things. First of all, there was an article in the New Yorker that was prohibited. The court put an order in place saying nobody in the UK could view it, and it was actually blocked on the internet, so you couldn't see it in this jurisdiction. Now, if I was the sort of person who advertised VPNs, I could say, oh, well, if you had a VPN, you could have seen that. But there was also something a bit more mysterious, which I'll come on to in a moment. But just to explain about the New Yorker article, why was that embargoed? The general rule is that we don't want to influence juries. Now, one thing you need to understand about criminal trial is it's not a search for the truth. The Crown have to prove their case, and the defence can sort of, challenge that. But not everything that is, relevant is admissible. So say, for instance, somebody confesses to a crime, but the defence raise an objection under what we call Section 76 of PACE and say the confession should not be admitted because it was obtained either under duress or as a result of an inducement. So therefore it is unreliable. And the test is, in that situation, the confession must be excluded, notwithstanding the fact it may be true. I mean, I suppose the ultimate thing is, you can't have somebody on a jury if they'd witnessed the event. Let's say it was like a punch up in a pub and somebody said, yeah, I saw that. Well, they'd be banned from being on the jury, even though by definition they're the best person to judge on that because they actually saw it. Juries in this country actually harken back to the Danelaw and the Viking days. And juries in those days were 12 people who actually knew everybody involved. And the idea was that by getting 12 people who knew sort of, everybody involved in the case, they would be in a much better position to judge what likely happened. That's obviously now evolved to the case where jurors have to come to the case and not know any of the parties. I mean, we don't have the voir dires and the big questionnaires like they do in the US to sort of, examine all their beliefs. We just pick the first 12 people out of the hat. And indeed, if we run out of jurors, we have a thing called paying the talesman, where the court bailiff can just go outside the court and just round random people up and go, do you want to be on a jury? But yeah, so the situation there was that there was an article in the New Yorker that raised certain challenges to the Lucy Letby conviction based on sort of, statistical evidence and things like that. But what the court said is, well, if the defence want to run that argument, then they can do. However, they have chosen not to. They don't think there's anything in it. Therefore, we don't want to risk a juror seeing that and going, well, hang on a second, maybe there's something in this. But it's just a magazine article. There's no way of testing that in cross-examination to see, the veracity or whether it's actually reliable. So that was the reason that the New Yorker article was embargoed. It wasn't anything particularly sinister. I mean, this is all very topical at the moment, with people being done for contempt for standing outside court saying, oh, jurors can acquit according to their conscience. See my other video on Bushell's case, which is the one that established all that. If I remember, I will actually link that at the end. But, it used to be, for instance, we would exclude people's previous criminal convictions. Because the argument was, you are not being charged with being a burglar. You are being charged with burglary on this one specific occasion. So the fact that you might have done it lots of times before is irrelevant. Stuff could actually go in if it was what we call similar fact evidence. So if it was something that was so unusual about the case, that what were the odds on it being a different person? And the example they always used to give was somebody goes like robbing banks, but they dress up as a clown when they do it. If you could say, well, he had previously robbed a bank while dressed up as a clown, And in this particular instance, there is somebody who robbed a bank dressed up as a clown. What are the odds on it being a different person? But if it was just like a general bank robbery type thing, you couldn't put in that somebody had previous convictions for bank robberies, because loads of people rob banks. Like I say, that has actually now changed. And it's very interesting that it used to be the forbidden argument that you couldn't put in previous convictions to prove propensity to commit crime, and now you can. But that's the reason that that article was excluded. However, there was something sort of, perhaps a bit more interesting, to use a phrase. So after the first trial, Lucy Letby applied for leave to appeal. Most of her grounds were to do with expert evidence, and they were saying that a particular expert the Crown relied on, he hadn't actually practiced as a doctor for like 12 years. He was just a professional expert now. And they said, well, look, how can he talk about this? He hasn't really been in modern practice. He's completely out of date. Also, he's gone beyond the remit. See my other video about expert evidence, where he's speaking about things he is not an expert in. However, the Crown, the court in that case, the judge at first instance, because when you go for an appeal, the first person you apply for leave to appeal, because you don't have an automatic right of appeal, you have to have leave. The first person you ask is the trial judge, and you say, look, judge, I think you got that wrong, can I have leave to appeal? And the judge said, well, no, I think I made the right ruling. So she applied to the Court of Appeal and said, I think the trial judge got that wrong and should have excluded the evidence from this particular expert because it wasn't reliable. And the court knocked them back. However, there was another ground of appeal, and that's the one I want to talk about, because this is what happened. While the case was going on, and just as the jury was sent out to consider their verdict, the court got an email from somebody whose initials are KC, saying, I work in a cafe, and somebody came in who I recognise as a juror on this case, and started talking about how the jurors had already made their mind up, they'd already decided she was guilty, they didn't need to hear the trial. I think you should know about that. Now that came to the attention of the judge. The judge quite properly said to defence and prosecution, I've got this email, do you have any thoughts about what we should do about it? And it was agreed between the parties, well, email her back and try and get some more information about this because it might be relevant. So the court emailed back and said, okay, this, we see what you say, but we need a few more details. Can you get in touch with us? Because they'd sent it, this had come from an email address. The person had given a particular name, but they hadn't given a lot of detail. And obviously, because this was quite a high-profile case, and it said things like, this should be brought to the attention of the attorneys. So the court was quite suspicious about this as to whether this was just an attempt to derail the trial. So they tried to contact this person, didn't get any response, but they put Greater Manchester Police on the case and said, okay, stick somebody there who's got no connection with this trial and see if you can find out who it is. And they tracked somebody down with the same name who worked for Tesco's, who had reported offences in the past, but when they interviewed that person, that was just stuff about shoplifting, and they said, okay, this isn't from you. So the judge said, over the defence objections, this is just clearly, there's nothing in this. It's an anonymous tip-off that doesn't really, that we've got no background detail on. I'm just going to send the jury out and let them consider. However, it then, the person did get back in touch and said, look, I work in this cafe, this particular juror came in and they said this. So the judge said, okay, I'll speak to this juror. And they got this one juror into the court in the absence of the rest of the jurors. And they said, do you know anything about this? And the juror said, well, I've never been in that cafe, but my girlfriend works there. And it then transpired that his girlfriend had a row about a mobile phone. She had arranged to sell her mobile phone to her boss in the cafe, and then the boss hadn't, just like not given her the money. She reported it to the police. The police turned up and said, oi, this is a civil matter. However, if you don't give her the money, we're going to treat it as theft. So either pay up or we'll nick you. And what was interesting then is the timing of this email was shortly after that. So the court's speculation was this was just somebody trying to get her into trouble or to cause trouble via her boyfriend, who was a juror on the case. And in the end they said, clearly this is just something. I mean, the defence said, well, no, we think you should get her in and we should be allowed to cross-examine as to whether this really happened. But the court said, look, this guy has said, you know, I've never even been in this cafe. He was quite open about, you know, knowing everybody. He said, you know, my girlfriend works in this cafe. And when they actually looked into it, they said, we think this is just somebody who's annoyed because, you know, the girlfriend got the police involved, just trying to cause trouble. And they actually, what's interesting, the Court of Appeal said, look, this judge has seen this juror for the 10 weeks that this trial went on, and apparently the juror was very conscientious, making notes. There were questions from the jury that seemed very sensible, and they said, as far as we can tell, there's nothing to suggest that this juror wasn't doing their job properly and taking their oath very, very seriously. So we're not going to allow that as a ground of appeal. However, that was the reason that this was all embargoed. Oh, is that still recording? Yeah. So there you go. So that was a bit of a mystery. This will probably all appear in tomorrow's papers. And by the time you see this, it might be tomorrow because I've got to go away and edit it and everything. And you probably hear I'm just a bit like, because I've been working, like it's been a nightmare day today, but I wanted to get that done for you. So there you go. So where am I today? I'm in Frogpool again at a pub I really like. I'm having a beer. I've just had some chips, which was a very late breakfast. So hopefully, if you did find that interesting, vaguely useful, vaguely informative, vaguely accurate, please consider liking, sharing, subscribing, etc., etc. And I'm going to go back inside where it's warm.